Blume Goldsamt, a New Jersey practicing attorney with over 30 years of experience in family cases and with over 20 years of experience mediating divorce and other cases. Today we're going to talk about litigating or mediating problems that come up after the divorce. In these tough economic times, many people are finding problems that they never expected, loss of jobs and other kinds of issues, which then make them rethink the property settlement agreement they signed. And the next thing they think of is whether they have to go back to court to get a modification to that agreement. Litigating in court has been shown to be very expensive and time-consuming, and I'm here to offer a better process, which is mediation. Mediation is more cost-effective, time-effective, and people usually indicate that they feel that they've gotten a better solution to their problems. But let's talk a little further. What happens and what kinds of cases can you mediate? You can mediate just about any kinds of issues, including child support, alimony, change of custody, college, just about anything except usually for division of marital assets and debts, which happen when the time at which people get divorced. What happens when you go to litigation? Well, you first have to hire an attorney. You have to come up with a retainer, and then the attorney has to prepare papers which you have to review and sign and get them filed. Then it's going to take you, at least in New Jersey, about a month just to get before a judge. And that's if your former spouse doesn't bring an application against you, in which case it's going to take way longer than a month. When the judge finally makes a decision, you could get a decision that you don't like. And if so, then you have to think about whether to appeal that decision. That can take weeks, months, or years before you get a decision. And of course, again, you could get a decision that you still don't like. What about mediation? If you mediate, things are quite different. First of all, you and your former spouse work with a mediator. The mediator helps you in establishing the issues and doing some homework and sharing information and documents so that you can better understand what's involved and be better at negotiating and developing options aimed at resolving whatever it is you need to resolve. The negotiations lead to you and your former spouse finding a solution that works for you and your family. Usually people find that those solutions are better because they've had an active role in creating those solutions. Can you use your attorney? Of course you can. Your attorney can give you advice during the mediation process, and your attorney eventually can write up a modification to your original agreement. Will the court accept this modification? Well, the fact is that at least in New Jersey, you don't have to go to court again. If you're doing a modification, all you need to do is work on with that modification with the mediator and your former spouse, and then get it drafted by the attorneys and signed by you and your former spouse, and you go on with your future lives. I hope what I've talked to you about today has been useful, and if you have any further questions, check out my website at mediate.com/goldsamt. Thanks for listening.